Welcome back. I've been going through this particular script for the past few days, and what held my attention wasn't the betrayal itself. It was the protagonist's choice to say nothing when he discovered the contract. Silence as a weapon is underrated. He used it with surgical patience. His eternal diary.
The smell of old paper and machine oil was the first thing Ethan Cole noticed every morning when he arrived at the offices of Harrington Group on the 41st floor of a building that hadn't been renovated since 2009. That detail mattered to him. The Harrington family was worth an estimated $4.2 billion across 3 continents, and their flagship legal office still smelled like a public library with water damage. There was a ceiling tile above the reception area that sagged in the middle like a full diaper, and the fluorescent light in the men's bathroom on that floor flickered twice per minute with a precision that Ethan had eventually stopped noticing. The same way you stop noticing the hum of a refrigerator until the power goes out and the silence hits you. He had been working at Harrington Group for 11 days when he found the contract. He was not supposed to find it. It had been filed in a secondary folder inside a drawer that had been labeled Miscellaneous Estate, pre-2021, in handwriting that wasn't his and wasn't anyone currently employed on the floor. He'd been looking for a deed of conveyance related to a property dispute in the Nevada portfolio, a property the Harrington family had owned since 1988 and was now being contested by a distant cousin with a new attorney and no apparent understanding of adverse possession law. He'd been methodical about it. That's the way he was methodical about everything. Left to right, front to back, nothing skipped, nothing assumed. That was how he'd made junior partner at Whitmore and Associates at 28, the youngest in the firm's 90-year history. That was how he'd built his reputation. Not brilliance, not genius, but the kind of patient, structural thinking that most people confused with both. The contract was 3 pages. Standard letterhead at the top. Also, the name of the issuing firm, Harrington Family Office, LLC, printed in small, tasteful serif font. The date was 14 months ago. The party of the first part was listed as Harrington Family Office. The party of the second part was listed as Vivian Park, described in the document as a contracted talent intermediary. Ethan read the word intermediary twice. Then he read the rest. The agreement was structured as a talent procurement contract, the kind used by private family offices to secure professional talent without going through standard headhunting firms. It was legal, it was clean. It had been drafted by someone who knew what they were doing, which made the whole thing worse because it meant no one had been sloppy about it. No one had made this mistake by accident. The language was precise. Vivian Park, as intermediary, agreed to facilitate the placement of one Ethan Cole, attorney, as at the Harrington Family Office for a term of no less than 12 months, during which time Mr. Cole would serve as primary legal counsel for estate matters including but not limited to trust administration, real property transactions, and intra-family dispute resolution. In exchange for successful placement and a retention period of no less than 6 months, Vivian Park would receive a one-time payment of $300,000, and with an additional $200,000 contingent on the subject's continued employment at the 12-month mark. $500,000 total. Ethan set the contract down on the desk and looked at the sagging ceiling tile for a moment. Vivian had told him about the opportunity 8 months ago. She'd framed it as something she'd heard about through a contact of hers, someone who worked in high-net-worth family services, she'd said. Vague in the way she was always vague when the details didn't serve her. She'd said the Harrington family was looking for a discreet, talented attorney who could handle complex estate matters. She'd said the pay was excellent, the work was interesting, and it would get him out of the grind of Whitmore and Associates, where he'd been watching senior partners take credit for his work for 3 years. She'd said she thought it was perfect for him. She had not said she was being paid to put him there. Yet he picked up the contract again and read it a second time, slower. His eyes moved over every clause, every defined term, every carefully worded condition. He was looking for the thing that would make it mean something other than what it clearly meant. The loophole in his own reading. There wasn't one. Vivian had signed on the line above her printed name in her handwriting, or a signature he recognized because he'd watched her sign her name on a birthday card for her mother 6 months ago, and thought, even then, that her signature looked like someone who was always in a hurry to be somewhere else. He folded the contract back exactly as he'd found it, returned it to the secondary folder, and slid the drawer closed. Then he sat there for approximately 4 minutes, looking at his hands on the desk. The fluorescent light in the bathroom flickered. He thought about what Vivian would say if he called her right now. From this desk, in this office, 11 days into the job she had sold him into, without his knowledge. He could hear it precisely. The way you can hear an argument in your head before it happens, because you've had enough of them to know all the shapes they take. She would be defensive first, then injured, then accusing. She would find a way to reframe her choices as acts of love. She'd done it for them, for their future, as he saw it for the stability she'd been trying to build. She would talk about the money and what it had paid for, as if the spending of it retroactively justified the method. She'd say he wasn't listening to her, that he never appreciated what she did behind the scenes to keep things going. And somewhere in the middle of all of it, she would start crying, which was not calculated on her part, but was functionally indistinguishable from calculated because it always worked, because he had always let it work, and because somewhere in the last 4 years, he had confused her unhappiness with his responsibility. He did not call her. Instead, he opened his laptop, pulled up the Harrington estate files he'd been given access to, and continued working. This was the moment, though he wouldn't have called it that at the time, when Ethan Cole decided to become someone else. Not in a dramatic sense, not in a way that required a declaration or a confrontation or a plan written out on paper. It was quieter than that. It was the same quiet that comes before a very clean structural decision, the kind where you recognize what the architecture actually is and start thinking about load-bearing walls. He knew where he was now. He had been placed. That was the word the contract used, and he was going to treat it seriously. He was in the Harrington estate, at the pleasure of a family. He'd had 11 days to study, doing work that was legitimately interesting and complex. Nasa for pay, that was better than anything Whitmore and Associates had offered him. The person who had arranged this without his consent was also the person he had been planning, in a diffuse and unexamined way, to spend his life with. He thought about the $500,000. He thought about the fact that Vivian had said 3 months ago that she'd paid off her business debts, the fashion consulting firm she'd launched in 2021, and watched collapse in 2022, and the one that had left her with approximately $400,000 in personal liability because she'd personally guaranteed the business line of credit. He'd never asked where the money came from because he'd assumed her family had helped her, and because asking about money with Vivian always generated arguments. Now he knew where the money had come from. He closed the estate files and opened a new document. He typed one line at the top, once a habit he'd developed in law school for organizing his thinking on complex matters. He typed, "What does this position actually offer?" Then he started listing. Alexandra Harrington did not look like a woman who had $400 million in her name. She looked like someone who had been awake for 30 hours and had made peace with that fact somewhere around hour 22. When she walked into the conference room on Ethan's 12th day, she was wearing dark trousers and a gray shirt that had been pressed at some point earlier in the day, but had since developed a crease along the left shoulder from what appeared to be a bag strap and flat shoes. She carried a coffee in one hand and a phone in the other, and she set both on the table with the careful precision of someone who had learned not to spill things in meetings, because spilling things costs time you don't have. She looked at him. He looked at her. She said, "You're Cole." "Yes." "I read your brief on the Whitmore property dispute." She sat down across from him and opened a folder she'd brought. "Your argument about the easement is correct, but the framing is wrong. You're approaching it as a property dispute when it should be framed as an estate administration matter. The distinction changes the venue and the timeline considerably." Ethan looked at her for a moment. "That's exactly right." "I know it's right. I'm telling you so you can fix the brief before we send it." She glanced up from the folder. "Is that a problem?" "No." She nodded once, the way people do when they've confirmed something they already suspected, and went back to the folder. Ethan had spent 3 years watching senior partners take 15 minutes to arrive at conclusions he'd reached in 3 weeks, and there was something genuinely disorienting about sitting across from someone who arrived faster. He fixed the brief. She reviewed it. She made 2 more changes, both correct. They spent 3 hours in that conference room working through the Nevada property matter, and somewhere in the 2nd hour, he stopped noticing the bag strap crease and started noticing the way she organized her thinking. Linear, rigorous, with an almost architectural sense of what each argument was load-bearing and what was decorative. She'd had no formal legal training. She held an MBA from Wharton and had spent 5 years at a private equity firm before her father's health had declined, and she'd come back to manage the family estate. She'd learned the legal elements the way he'd learned financial modeling, because the work required it, and because she had no patience for being dependent on other people's expertise in areas she could master herself. At 4 o'clock, she closed her folder and said, "Mom, you're better than the last 2 attorneys we had in this position." "What happened to them?" "The first one tried to overcharge us for paralegal hours and assumed I wouldn't check." She picked up her coffee, which had been cold for 2 hours. "The second one was competent, but had a conflict of interest issue with a counterparty I didn't discover until 6 months in. It cost me a settlement." Ethan said nothing. "You have a better instinct for estate law than your background suggests." She looked at him with the direct, assessing quality that he was coming to recognize as simply how she looked at things. Not aggressive, not performative, just accurate. "Where'd that come from?" "My grandmother," he said. "She owned 3 commercial properties in Baltimore. She didn't have good legal representation, and she lost 2 of them to estate disputes after her husband died. I was 15, and I watched it happen." Alexandra was quiet for a moment. Then she said, "That's useful context." She stood, picked up her phone and the cold coffee. "I want a memo on the trust amendment by Friday. Not the standard boilerplate. I want your actual analysis of the risk exposure." She left. Ethan looked at the folder she'd left behind. Deliberately, he realized, her copy of his original brief with her handwritten notes in the margin, left so he could study them. He studied them. Aunt Vivian called on a Thursday evening, 3 weeks into his tenure at Harrington Group. She called with the cheerful energy of someone who had been managing her own guilt by staying busy. She asked how work was going, whether he'd settled in, whether the commute was manageable. She said she missed him. They'd been spending fewer nights together since he'd started the new position, which she framed as understandable given the demands of the role she had arranged for him. She said she was thinking they should go away for a weekend, somewhere quiet, maybe Sonoma. She'd been looking at a small inn there, reasonable rates, good wine list. Ethan said, "That sounds nice." His voice was even. It had been even for 3 weeks, since the afternoon with the contract and the folded paper, and the 4 minutes of looking at his hands. He had not changed his tone with her. He had not become cold or distant in any way she could identify. Catalogue. What he had been, exactly what he had always been. Attentive when she needed attentiveness. Easy company over dinner. Reliable in the small, textural ways that she'd come to expect from him so thoroughly, she'd stopped noticing them. The same way you stop noticing the hum of a refrigerator. Until the power goes out. He was not planning anything consciously. That was important to understand. He was not sitting in his apartment with a whiteboard and a timeline, plotting. He was simply working. He was doing the job he had been placed into without his knowledge, and he was doing it the way he did everything, with the methodical patience of someone who believed that understanding the architecture always comes before deciding which walls to move. He was learning the Harrington estate the way a surgeon learns an anatomy. Not to harm it, but because you cannot operate on something you don't fully understand. The estate was substantial and genuinely complex. It comprised, across its various entities, 11 commercial properties in 4 states, a residential portfolio of 17 units in New York and Connecticut, 2 private equity fund interests, a family foundation with a separate endowment, and a trust structure that had been established in 1991 and amended 7 times since, each amendment leaving behind sediment, conflicting provisions, outdated beneficiary designations, language that referred to circumstances that no longer existed. As the previous attorneys had, in Ethan's assessment, been managing the complexity rather than resolving it. They'd been treating the estate like a patient you maintain, rather than a patient you cure. He started writing a comprehensive audit memo 3 weeks in, not at anyone's request. He wrote it because it needed to be done, and because doing it would require him to understand every corner of the Harrington estate's legal structure in a way that no previous attorney had apparently bothered to do. And when Alexandra found the audit memo on her desk on a Friday morning, he'd emailed it at 11 the previous night, 43 pages, footnoted, with a 3-page executive summary and a chart of the 12 most significant legal vulnerabilities in the trust structure. She read it over the weekend and called him on Sunday. "This took you how long?" she said. "About 6 evenings." She was quiet for a moment. "Pull everything related to the 2017 trust amendment. I want to go through it with you tomorrow morning." "I already pulled it. I'll have a working analysis ready." Another brief silence. "Early start, 7:30. He was there at 7:15. She arrived at 7:20, carrying 2 coffees, and handed one to him without comment. It was the first time she'd done that. The 2017 amendment was the one that mattered. Ethan had identified it in the audit as the most significant structural problem in the estate, but he'd written the finding carefully in the neutral, measured language of a technical memo. Because even at 6 evenings in, he understood that the finding was not just legal, it was personal. The 2017 amendment had been executed by Alexandra's father, Richard Harrington, at a moment, late 2017, about 14 months before his first stroke, when his judgment had apparently been influenced by a set of circumstances that Ethan had pieced together from the document trail without having all the pieces. The amendment had shifted the distribution provisions of the main family trust in ways that significantly disadvantaged Alexandra's share relative to her 2 older brothers, Charles and William. The legal language was valid on its face, but the circumstances of its execution had gaps. Gaps that, in Ethan's professional opinion, were exploitable. He laid it out for her that morning at 7:30 across the conference table, using a clear, systematic presentation. No drama, just the architecture. He walked her through the execution date, the attorney who'd drafted it, a firm that had since dissolved, the 2 witnesses, one of whom had died in 2019, and the specific provisions that had been altered. He showed her the comparison between the 2014 version and the 2017 version. And he marked the 3 places where the language had shifted in ways that were not consistent with the estate plan's established pattern or with the notes in the family office's files from that period. Alexandra listened without speaking. She had a legal pad in front of her, but she wasn't writing. She was watching him with the focused, contained attention he'd come to expect from her. The kind of attention that didn't interrupt because it was too busy understanding. When he finished, she said, "But you think the amendment can be challenged?" "I think there's a credible basis for a challenge on grounds of undue influence, based on the circumstances of the drafting and your father's health timeline. The challenge would be complicated by the fact that 2 of the witnesses are unavailable, 1 deceased, 1 relocated internationally, and unresponsive. But the gaps are real, and in a trust contest proceeding, the gaps cut against the party trying to uphold the amendment, which would be Charles and William." "Yes." She looked at the marked copy of the 2017 amendment on the table between them. "My brothers have known about this vulnerability since 2019. They've been waiting for me to miss it." Ethan said nothing. "I've been operating under the assumption that the 2017 distribution was fixed." She turned the legal pad face down. "How long would a challenge take?" "Anywhere from 18 months to 3 years, depending on whether they contest it aggressively or try to negotiate." "What's the strategic framing to minimize the timeline?" "File the challenge as a trust administration proceeding, rather than a contest," Ethan said. "Different venue, more favorable procedural rules, and it reframes the parties. You're not litigating against your brothers. You're asking the court to supervise administration of the trust. And it reduces the personal conflict optics and makes settlement more attractive to them." She was looking at him now with an expression he hadn't seen before. Not gratitude. He would have noticed gratitude. It would have seemed out of place on her face. It was something more calibrated than that. The expression of someone who has found, after a long time of looking, a tool that actually fits the task. "Write the complaint," she said. "I'll need you to authorize engagement of outside litigation counsel. I can draft, but trust contest proceedings require. I know what they require. I'll authorize outside counsel. You'll lead the strategy." She stood, picking up her coffee. "And Cole?" "Yes." "This doesn't leave this room until I say it does." "Understood." He was 3 months in when he found the second document. This one he was supposed to find. It was in a folder on the shared drive, labeled clearly. Filed in the proper location. It was a copy of the original talent procurement contract, not the physical copy he'd found in the drawer, but the digital version, saved to the family office's secure document system. The file metadata showed it had been saved there by Alexandra Harrington on the same day it was executed, 14 months ago. She had always known he would eventually find it. He sat with that understanding for a full evening. He thought about the way she'd spoken to him at their first meeting, not as a stranger, but as someone whose capabilities she'd already partially assessed. He thought about the coffee she'd handed him on a Sunday morning 3 months in, without being asked. He thought about the audit memo sitting on her desk when she arrived, and the fact that she'd called him from home on a weekend, which she only did when something mattered. She had purchased his placement. That was the truth of it. On the architecture beneath everything else. Vivian had been the intermediary, the contract's language, but the decision to acquire his services through that method had been the Harrington family office's decision. Alexandra's decision. Or at minimum, her ratification of it. He thought about that for a long time. He thought about the fact that she had never pretended the position had come to him through normal channels. She had never told him anything false about how he'd come to be there, and she had simply not told him the full truth, which was not the same thing, legally speaking, though it felt, in the human register, rather similar. He thought about Vivian, who had told him something false, who had dressed the arrangement in the language of opportunity, of care, of doing something good for them both, who had looked at him across a dinner table and said, "I think this could be really good for your career," and had meant, "I signed a contract that pays me if you stay." And the distinction between the two women resolved itself for him that night with the cold clarity of a well-drafted statute. He wrote a single note on the legal pad he kept on his nightstand for case observations. Alexandra paid for professional access. Vivian sold personal trust. He looked at the line for a moment. Then he turned the pad face down, which was the gesture, he realized, that he had adopted from Alexandra. The trust challenge filing was ready in month 4. As Ethan had spent 2 months on the complaint working with Miriam Cross of Cross and Whitfield, the outside litigation counsel Alexandra had engaged. A woman in her late 50s with a reputation for trust and estate work that was, in the field, roughly equivalent to being a reliable structural engineer. Not glamorous, but the person you want when the building has to stand. Miriam had taken one look at Ethan's draft and made 4 changes and a single comment at the bottom in red ink. "This is the cleanest trust contest complaint I've read in a decade. Don't change the venue argument." The filing landed on Charles Harrington's desk on a Wednesday morning. Ethan knew this because one of the family office's administrative staff mentioned, in passing, that Charles had called the office 3 times before noon and asked to speak to Alexandra, who was in meetings. Yet the third call had apparently been somewhat less polite than the first 2. He did not see Alexandra's expression when she listened to the voicemails. He did see her expression at 2:30 that afternoon when she came into the conference room where he was working on a property acquisition review for the estate's Connecticut holdings. She sat down across from him with the same contained quality she always had, the same directness. But there was something slightly different in the room that day. An atmospheric shift, the way a pressure system changes before weather. She said, "Charles is claiming the challenge is a violation of the family's mediation agreement." Ethan had read the mediation agreement in week 2. "There's no mediation agreement. There's a letter of understanding from 2018 that's not binding and was never executed as a formal agreement." "I know that. He knows that too." She looked at him. He's trying to rattle you. He's trying to see if I know what I'm doing. I do." She held his gaze for a moment that was slightly longer than operational. "Yes," she said. "I know." She stood. "I'll handle Charles directly. You'll hear from William's attorney by end of week. William is more careful than Charles, and his attorney is better. Prepare for that conversation." "I'm prepared." She picked up her coffee and left. Ethan went back to the Connecticut Acquisition Review, which had its own complications. A lien that had been improperly released in 2015 and had left a clouded title on a property valued at approximately $8 million and worked steadily until 7 o'clock. He did not call Vivian that evening. He was 3 days past when he usually called, and he knew she'd noticed, because she'd texted twice in a friendly, asking tone that had a tight, slightly performative quality underneath it. The kind of tone that isn't actually relaxed, but is performing relaxation for the reader. He looked at the texts. He thought about what had been done. He put the phone down and made himself a meal and went to sleep early, the way you do when you are conserving something. Month 5 brought the deposition of a trust officer who had witnessed the 2017 amendment's execution and whose testimony, under cross-examination by Miriam Cross, produced a 20-minute sequence that Ethan had been building toward for 2 months. The witness confirming, under oath, that Richard Harrington had appeared, at the signing, to be confused about the specific changes being made, and had asked the drafting attorney to re-explain 2 provisions. Twice. What Ethan had found this witness, through the corporate filings of the now dissolved drafting firm, and had spent 3 weeks preparing a deposition outline that worked backward from the one thing he needed the witness to confirm, building every prior question as a structural support for that single, load-bearing moment. Miriam Cross said afterward, in her measured way, "That was very well constructed." "Thank you." "You've done trust contest work before?" "Not formally. But the architecture is the same as any complex transaction." He paused. "You work backward from what the result needs to be, and you build every element as structural support." Miriam looked at him with the appraising look of someone recalibrating. "I may want to bring you in on a matter in the fall." He said, "Let's see how this resolves first." Vivian came to see him in month 6. She drove to his apartment on a Sunday morning without calling ahead, which was a behavior he associated with her when she was managing anxiety by converting it into action. She knocked on his door at 10:30. She was wearing a tan coat he'd bought her for her birthday 2 years ago, which he noticed, and she had a coffee from the place 2 blocks away that he liked, which she'd stopped at on her way, which he also noticed. The performance of attentiveness that arrives when someone has sensed, without being able to name it, that they are losing ground. "Sometimes." He let her in. She sat on his couch and talked for an hour. She talked about the Sonoma trip they'd never taken, about the fact that they'd barely seen each other in 2 months, about whether the demands of the Harrington position were too much, about how she missed him. She cried a little, genuinely, which made it worse in the specific way he'd already mapped. She said she felt like she was watching him disappear into a job that was consuming him, and she didn't know how to compete with it. Ethan sat across from her and listened. He was very good at listening. He had always been good at listening. It was what made him effective in depositions and useful in negotiations, the ability to be completely still and receptive while also tracking, at a structural level, the shape of what was being said. What it wasn't. What it assumed. What Vivian was doing, he understood, was trying to feel secure. She had done something that she had justified to herself as practical, as pragmatic, as an act of resourcefulness in difficult circumstances, and the justification had held until the person she'd done it to had begun to seem, in small, unnameable ways, like someone who knew. And not knowing whether she knew he knew was, for Vivian, the most unbearable state, because Vivian needed resolution. She needed either the confrontation or the reassurance. Ambiguity was where she was least functional. He didn't give her either. He was warm. He was present. He held her hand at one point and said the right things about the demands of the position and the adjustment period and how they would find their rhythm again. He made them lunch. He made her laugh twice. When she left at 2 o'clock, she was in a better mood than she'd arrived in, and he stood at the window and watched her car pull away from the curb with the particular stillness of someone who is not confused about what they are doing. He had not decided what to do yet. That was the truth. That he was gathering information. He was understanding the architecture. He was not going to move a wall until he knew exactly which ones were load-bearing. That week, Alexandra called him into her office. The actual office, not the conference room, which she used when the conversation was operational. She did this rarely. The office was on the corner of the 41st floor and had 2 large windows that looked northwest over the city. There was a small credenza along one wall with 3 framed photographs that he'd never looked at directly, but had catalogued peripherally. One with an older couple he assumed were her parents, one with a group of people his age, and one of a coastline, somewhere cold and gray, that she must have chosen to look at every day for a reason. She was standing at one of the windows when he came in. She turned and gestured to the chair across from her desk. I want to discuss the trust filing's strategic timeline," she said. He sat. The mediation demand from William's attorney creates a decision point. If we engage the mediation process, we can potentially shorten the timeline, but we reduce the leverage the deposition testimony gives us. If we decline and push toward a hearing, we maintain the leverage, but the timeline extends by 4 to 6 months. She was watching him. What would you do? I would engage mediation as a procedural courtesy, attend one session, present the core of the case, make clear we're prepared to proceed to hearing. Use the session as a demonstration, not a negotiation. It communicates strength rather than eagerness. And you think that changes William's calculus? William's attorney has already seen the deposition transcript. William knows what the hearing will look like. He paused. He'll want to settle before the testimony is publicly filed. She was quiet for a moment. Then she said, "You found the contract." The shift was clean and direct, with no preamble, the way she operated. He had known it would come this way when it came. He had been waiting for it for 3 months. "Yes," he said. "When?" "Month 2, in the secondary files for the Nevada portfolio." She nodded once. "I'm sorry for the way it was structured." "Which part?" "The fact that you weren't consulted." She held his gaze without flinching from it. "The practical result, a well-compensated position doing work that's professionally interesting and that you're skilled for, that I don't apologize for. The method, yes." Ethan looked at her for a long moment. He thought about the 4 minutes with his hands on the desk. He thought about the note on the legal pad. He said, "Why that method? Your firm wasn't going to let you go easily, and I needed someone who would actually do the work, not someone who thought they were doing me a favor by showing up." She glanced toward the window briefly, then back. "Your girlfriend approached my office 18 months ago. She'd heard through professional contacts that we were looking for legal talent. She came with a portfolio of your work, publicly available filings, bar publications, so 2 brief analyses you'd written for a corporate law journal. She made the case for you better than a traditional recruiter would have." Ethan said nothing. "I knew she was doing it for the money. The contract was her proposal." Alexandra's voice was precise and unapologetic. "I used the mechanism because it worked, but I want to be clear, I was buying your professional services, not you." "I understand the distinction." "Do you?" "I'm still here," he said. She looked at him, was a silence that was slightly longer than operational. Then she nodded once, turned to her desk, and picked up a folder. "The mediation session. I want the presentation ready by Thursday." He stood. "It will be." He was almost at the door when she said, "Cole." He stopped. "The Sonoma Inn," she said. "The one your girlfriend mentioned to you in March. It's owned by a subsidiary of a trust that has a complicated relationship with our estate's foundation endowment. If she's made a reservation there, then have her cancel it." He turned around. "Is that a professional recommendation?" "It's a factual observation." A pause. "The ownership situation is complicated." He looked at her. She was reading the folder. He left. He thought about that conversation for the rest of the week. He thought about it the way he thought about a particularly elegant piece of legal drafting, not by analyzing it into parts, but by sitting with its whole shape, the way you hold a well-made object. He had been told, but in precise, unadorned language, that someone had studied his work carefully before acquiring his services. He had been told that the person who sold access to him had approached the arrangement as a business transaction and presented his professional history as a product. He had been told, in the careful framing of a professional apology that was not exactly an apology, that the buyer recognized the ethical complexity of the mechanism without regretting the outcome. And then he had been handed a piece of information about a Sonoma Inn that had no operational significance to the trust challenge proceeding or to any matter he was currently working on. He sat with that last piece for a very long time. He did not cancel any reservations. He did not call Vivian. He went to the office on Thursday with the mediation presentation, and it was precise and cold and beautifully structured. And when Miriam Cross reviewed it, she said, with characteristic understatement, "This is how you do it." The mediation session was on a Tuesday in month 7. William Harrington's attorney, a lean, careful man named Bauer, who had practiced trust litigation for 20 years and had the permanently unsurprised look of someone who has seen every variety of family dysfunction, sat across the table and listened to Ethan present the case's core with the focused attention of a man taking inventory. He asked 3 questions, all procedural. He made no argument, and he thanked them for the presentation in the professionally neutral tone that, in Ethan's experience, preceded settlement offers. The settlement offer came 11 days later. William's attorneys proposed a redistribution of the trust that restored 2/3 of Alexandra's reduced share, offered a buyout mechanism for the remaining portion, and included a mutual release of all claims related to the 2017 amendment. Alexandra read the offer in his presence and said, "They think I'll take it. They think it's generous enough." "Is it?" "As a settlement, yes. As justice for what the 2017 amendment actually cost you, no." He paused. "The decision turns on whether you want resolution or vindication." She looked at the settlement document on the desk. "Legally, what's your recommendation?" "Accept the restoration and the buyout. Bank the capital, and restructure the portion you recover into a direct distribution trust with a separate trustee to prevent future amendment without your consent. You end up in a stronger structural position than you were in 2016. And strategically? You file the counterproposal with 2 modifications. The buyout mechanism needs a clear valuation formula pegged to current market values rather than the formula they've proposed, which is based on 2019 asset values and underprices the Connecticut portfolio by approximately 12%. And you require a trust protector provision going forward, naming an independent party with amendment veto authority. She looked at him. The trust protector idea. That's not standard. It's increasingly used in sophisticated estate planning, and it makes future manipulation of the trust structure significantly harder. He paused. It's a structural fix. It's not just a settlement. She was quiet for a moment. Then she said, "Draft the counterproposal." He was at the door when she said his name again. "Cole." He stopped. "What would you have done in 2017, if you'd been the attorney?" He thought about it honestly. The 2017 amendment had structural weaknesses that an attentive attorney would have flagged before execution. If I'd been the drafting attorney, as I wouldn't have executed it without a more thorough capacity assessment and a clearer record of the client's understanding of the changes. He paused. If I'd been your attorney, I would have advised against signing. She looked at him with the expression that wasn't gratitude, but was adjacent to something. You would have lost the engagement. Probably. Most attorneys don't make that trade. I know, he said. Now, that's why most attorneys are managing complexity rather than resolving it. He left. Month 8 was when he realized, with the clean and undramatic clarity of someone arriving at a legal conclusion they've been building toward for weeks, that he was in love with Alexandra Harrington. He recognized the quality of the realization. It was structural. It was the kind of knowledge that arrives not as an event, but as a discovery of something that was always there, was the way you find the load-bearing wall when you finally look at the blueprint carefully. He had been mistaking it for professional respect, which was real and present and significant in its own right. But respect, he understood now, did not produce the particular quality of attention he paid to her. The way he catalogued the photographs on her credenza without looking at them directly. The way he'd memorized the specific pattern of her thinking without intending to. The way the Sunday morning coffee had meant something to him that professional courtesy did not account for. He didn't do anything with this realization immediately. He was not impulsive. He had never been impulsive. He had learned, over the course of 31 years and one betrayal, the value of knowing before acting. Vivian texted him 3 times in week 32. The texts had the slightly frantic energy of someone who had been waiting for a resolution that wasn't coming. And she asked when they were going to have dinner. She asked whether everything was okay. She asked, the 3rd text, sent at 11 at night, whether he was happy at the Harrington position, whether he thought it was the right fit long-term, whether maybe they should talk about next steps. He read the 3rd text and understood that what she was actually asking was, "Are you still mine?" He put the phone down and looked at the ceiling and thought about the contract, the talent procurement contract, and the mechanism that was her proposal, per Alexandra's precise description. The $500,000, the dinner table conversation, the "I think this could be really good for your career," the performance of attentiveness in service of a transaction she'd already made. He typed, "I'll call you this week." He called her 4 days later, on a Thursday evening, and told her they needed to talk. She suggested dinner. He said yes, a restaurant near her apartment, was somewhere public and reasonably quiet and unfamiliar to both of them, which she interpreted as him wanting somewhere nice, and he chose because public spaces constrain behavior. They sat across a table in a restaurant with warm light and cheap prices, and Ethan ordered the same coffee he always ordered, and Vivian ordered wine. And he watched her process across the first 15 minutes of conversation, the fact that this dinner was not what she'd hoped it would be. But he told her he'd found the contract. He said it at a natural pause in the conversation, in the same tone he used to explain a legal concept to a client. Not aggressive, not emotional, just present and clear and specific. He said he'd found the talent procurement contract filed in the Harrington Estates records 8 months ago. He said he understood the financial pressures she'd been under. He said he understood that she'd framed it to herself, probably, and as something she'd done for their future. He said he did not intend to have a long conversation about why she'd done it or what she should have done instead. He said, "We're done." Vivian went through the stages he'd predicted, in the order he'd predicted them, with the specific rhythm he'd already heard in his head 9 months ago, sitting at a desk with his hands folded. Defensive. Injured. Accusing. The argument about what she'd done for their future. The tears, genuine, which still produced the same response in him that they always had. The pull of old habit, the familiar weight of her unhappiness. But the architecture was different now. He had new blueprints. He did not engage. He did not comfort. He listened, which was different. He let her say everything she needed to say, and when she was finished, he said, "I hope you find what you're looking for," and he left the restaurant. And he walked 4 blocks in the night air before getting in a cab, and he felt, so with the clean simplicity of a structural decision correctly executed, the specific weight of something he'd been carrying without naming for a very long time come fully off his shoulders. He did not tell Alexandra about the dinner with Vivian. He did not tell her he'd ended the relationship. He returned to work on Friday morning and completed the counter-proposal on the trust settlement, and attended 3 meetings and ate lunch at his desk, and was, externally, exactly what he had been the day before. He was, internally, a different structure. Month 9 began with the counter-proposal negotiations. William Harrington's attorney came back with a modified valuation formula that was marginally better but still underpriced the Connecticut portfolio by 6%. Ethan rejected it in a single-paragraph letter that Miriam Cross called almost rude in its precision, which he took as a compliment, while William's side came back again with a formula he'd pre-approved. The trust protector provision took 3 more weeks and required a 3-hour call with both brothers' attorneys, during which Charles's attorney became, at one point, audibly frustrated. Ethan's voice did not change for 3 hours. The settlement was executed in month 10. Alexandra recovered 82% of her original beneficial interest. The Connecticut property's value was correctly reflected. School and the trust protector provision installed an independent fiduciary whose approval would be required for any future amendments affecting distribution. Miriam Cross said it was one of the better trust contest resolutions she'd seen in terms of structural outcome. The Wall Street Journal's estate law column ran a brief item on the settlement's terms as an example of the trust protector mechanism being used in private family estate disputes, but citing only the settlement as a matter of public record and not the parties. Alexandra called him into her office 3 days after the settlement closed. The afternoon light was coming through the northwest windows in a way that changed the room. She was standing at the credenza when he came in, and she turned and said, "Sit down, Cole." He sat. She stayed standing. "The 12-month mark is in 6 weeks. He looked at her. I'm aware. The second tranche of the procurement fee pays out at the 12-month mark. She looked at him with the direct, containing quality he knew. I want you to know that the arrangement with your former girlfriend terminates at that point. The financial obligation completes. I know how the contract reads. I'm not talking about the contract. She moved to the window, which she only did when she was assembling something. I'm talking about what comes after the contract. He was quiet. I want to offer you a permanent position, she said. Staff attorney, general counsel, with authority over the full estate portfolio. The compensation package I have in mind is significantly above your current rate. I'll review the offer. You'll accept it, or you won't. I want your honest answer, not a professional one. She turned from the window and looked at him. I'm asking whether you want to stay. He looked at her for a long moment, at the photographs on the credenza, at the gray coastline in the third frame, somewhere cold that she'd chosen to look at every day. Yes, he said. Something in her face shifted. The finest possible adjustment, the way a very controlled structure shows stress before it redistributes. Good, she said. I'll have the offer drafted by end of week. She turned back to the window. He stood to leave. Cole. He stopped. Why, she didn't turn around. The photographs on the credenza, the coastline on the right, that's the Faroe Islands. I went there after my father's first stroke, when I didn't know yet whether I was staying or going back to the fund. A pause. I stay for things that are worth staying for. He looked at the back of her head for a moment. Then he said, I know. He left the office. He stood in the corridor outside for exactly 12 seconds, which he knew because the fluorescent bathroom light flickered twice. The permanent offer came on a Friday. He reviewed it over the weekend, not because he needed to think about whether to accept, but because reviewing documents carefully was how he operated. The compensation was excellent. The authority was clear. The provisions were fair. He signed on Monday morning and delivered it to Alexandra's office before the day started, placing it on the center of her desk with a sticky note that said only, accepted. He had been working for her for 11 months. He had been in love with her, by his own accounting, for 3. He understood that the professional relationship and the personal feeling were distinct categories that required distinct handling, and he had not allowed one to contaminate the other because the estate work was too important, and because he had too much respect for her, for the quality of her thinking, for the accuracy of her self-understanding, for the way she had never pretended to him about anything, to introduce ambiguity into a structure that was working. The work came first. The work always came first. But on a Tuesday evening in month 11, they were working late in the conference room on a new acquisition in the estate's commercial portfolio, a retail building in Philadelphia that had a complex ground lease situation and a tenant with a disputed right of first refusal. And they had been there since 7 in the morning, and it was now 10:45 at night, and the only light in the building was the conference room and the flickering bathroom and the security desk downstairs. And they'd sent out for food at 8 o'clock and eaten at the conference table without stopping the conversation about the ground lease, which had a reversionary clause that was ambiguously drafted and which Ethan had been building a legal argument around for the past 3 hours. Alexandra had taken her jacket off 2 hours ago. She was sitting sideways in her chair, with the ground lease spread across the table in front of her, one hand resting along the back of the chair. And she was looking at the reversionary clause with the focused stillness that he associated with her most concentrated thinking. The room smelled like takeout containers and coffee and old paper. Her coffee was cold again. He said, "The use it or lose it provision in the reversionary clause is the key. If we can establish that the ground lessee hasn't exercised a qualifying use in the relevant period, and the reversionary interest comes back to the fee owner automatically." How do we establish that? Property tax records, utility records for the period, any local municipality records on building permits or certificates of occupancy. If they haven't been using the property in a qualifying way, there will be a record gap. That's forensic work. Yes, I know someone at a property forensics firm who does exactly this. He paused. It'll take 4 to 6 weeks. She turned and looked at him. They had been in the same room for 15 hours, and she looked exactly as calibrated as she had at 7 that morning, which was the kind of thing he'd stopped being surprised by and started being impressed by a long time ago. She said, "It's almost 11. I know. You've been here since I got in. I was here before you got in." She looked at him in the way that wasn't gratitude, but was something adjacent and significant. Yet the room had the particular quiet of a building that is emptied out around 2 people who haven't noticed. He said, "Alexandra." She held his gaze. "Ethan." It was the first time she'd used his first name. He said it carefully, with the precision of someone who has rehearsed nothing and is therefore saying exactly what is true. "I want to be clear about something that is not about the work." "Yes," she said. "I know." I know," she said again. She stood from the chair, and she was 3 feet from him, and the takeout containers were between them, and the ground lease was spread across the table, and the bathroom light flickered twice from the corridor, and she said, "I have known for 4 months." He looked at her. "And?" She reached across the table and picked up her cold coffee and drank the last of it with the steady, specific gravity of someone making a decision. She set the cup down. She looked at him with the direct, assessing quality that was simply how she looked at the world. "And," she said, "I'm not your employer anymore. I'm your general counsel's office, which is a different relationship." A pause. "As of this Monday's date on the permanent offer," he said, "that's a technically precise observation." "I know," she said. "I thought you'd appreciate it." He looked at the space between them. So he thought about the fluorescent light, and the cold coffee, and the 15-hour day, and the property records that would take 6 weeks, and the 3 photographs on the credenza. He thought about a coastline in the Faroe Islands, and a woman who stayed for things that were worth staying for. He said, "Have dinner with me." She said, "Tomorrow, 7 o'clock. Somewhere with food you can actually eat at the table, rather than over a lease document." "I know a place." "I'm sure you do." She picked up her jacket from the chair. "Good night, Cole." She left. He sat in the conference room for a while longer, in the near dark, with the ground lease in front of him, and the feeling that came through him was not dramatic. It was structural. It was the feeling of a building that has been properly load-bearing all along, finally settling into its foundation correctly. The dinner happened, and the one after that, and the Saturday afternoon in month 12, when she took him to see the Connecticut property. $8 million of clouded title and improperly released lien, which he'd resolved in month 5 by tracing the 2015 lien release to a title insurance error and negotiating a remediation with the insurer. As they stood in front of the building on a street in New Haven on a cold October Saturday, and she looked at it and said, "I almost sold this in 2020. I couldn't get clean title and I thought it was more trouble than it was worth." "It's worth approximately $9.2 million on today's market," he said. "I know." She glanced sideways at him. "You saved me over $1 million on one property. Among others. Among others." She put her hands in her coat pockets. "That's an unusual feeling." "What is?" "Having someone in your corner who actually knows what they're doing." She looked at the building. "I've spent a long time surrounding myself with competent people. Competence is easier to find than you'd think. What's harder to find?" She paused, as if she was being as precise as possible about this, "is someone who cares whether the thing is actually fixed. Most competent people are managing. You fix," he said. "What you?" "I had a good reason to care about this particular estate." She turned and looked at him. The October light was flat and cold and honest, the kind of light that doesn't do anyone any favors and shows everything. "Yes," she said. "I know you did." He looked at her. He thought about what he wanted to say. He said, "I'm not going to pretend the way I got here was clean. It wasn't. What was done without my knowledge was a violation of something I had a right to decide for myself." He paused. "But where I've arrived, what I've built in this year, professionally, with you, I don't regret arriving here. I regret the method and not the destination." She was quiet. "That distinction matters to me," he said. "I wanted to be clear about it." She looked at the building for a moment. Then she said, "The method was mine as much as Vivian Park's. Arguably more, since I authorized the structure. I know. I'm not apologizing for it again. And I apologized once, and I meant it." She turned to look at him. "But I am acknowledging that you're still here despite the method, and that's not something I take for granted." He looked at her, at the coat and the flat shoes and the hands in the pockets, at the expression on her face that was not gratitude but was, he understood now, something considerably more durable than that. He said, "I know you don't take it for granted." They walked back to where they'd parked in the cold October air, and at some point between the building and the car, their hands were the same temperature, and there was no reason not to. He proposed in month 14. He did it the way he did everything, without performance, without scenery, without a plan that required the participation of restaurant staff or ambient lighting. They were in her kitchen on a Sunday morning, which had become a regular geography for them over the preceding months. His apartment had receded into professional distance, and hers had opened up in the way that a well-used space does when it begins to hold two people's habits. She was reading something, standing at the counter with coffee. He was reading the property forensics report on the Philadelphia ground lease, which had resolved favorably. Also, the apartment smelled like coffee and newsprint, and a specific quality of morning that he'd started to think of as structural, as load-bearing. He looked up from the report and said her name. She looked up from what she was reading. He said, "I want to marry you." She looked at him for a long moment, with the direct, containing quality that was simply how she encountered the world. She put her reading down. She said, "Yes." No scenery, no ambient lighting, no performance. Was just two people with a clear-eyed understanding of what they were each worth and what they'd built, and why it was worth building correctly from the start. He said, "I'll need to review the prenuptial agreement carefully." She looked at him. "I know you will. I'll probably find some things to change. I expect you to. And I'm going to insist on the trust protector model for the joint estate structure. The same mechanism we used for your family trust." "Of course you are." Something in her expression shifted in the specific way he'd cataloged. The finest adjustment, the warmth that operated like a precision instrument. "Ethan?" "Yes." "Stop working." He put the report down. She put her coffee down. The Sunday morning held them with the particular quality of something that has been carefully and correctly built. Yet they were married 14 weeks later, in a ceremony that was small by any standard, and especially by Harrington estate standards. 22 people in a room overlooking the water, a judge they both knew from the estate proceedings, a dinner afterward at a restaurant with honest food and tables you could actually eat at. Miriam Cross was there. 3 people from the family office. Alexandra's closest friend from Wharton, who spoke at the dinner with the dry, was some precise warmth of someone who had been watching for Alexandra to find this and had stopped waiting. 2 people from Ethan's life who were old enough in his history to understand what this represented in context. The brothers were not invited. The brothers were, at the moment of the wedding, occupied with their separate attorneys reviewing the implications of the trust protector provision, which had already blocked one attempt by Charles to push through an amendment in the 3 months since the settlement. Ethan wore a dark suit that fit correctly, which was the only standard he applied to clothing. Alexandra wore something he had not seen before, a deep blue that was neither ornamental nor understated. It was simply exactly right. The way her thinking was exactly right. The way she was always the precise instrument for the task at hand. And he looked at her across the small room when the judge was speaking and thought about the fluorescent light and the cold coffee and the audit memo and the coastline in the 3rd photograph on the credenza. He thought about the contract in the secondary drawer and the 4 minutes with his hands on the desk and the note on the legal pad that he'd turned face down. Alexandra paid for professional access. Vivian sold personal trust. He had understood the distinction then. But he understood it more fully now. Vivian Park came back on a Wednesday in February. Not in the way of a story that requires announcements and dramatic returns. She sent an email to the family office's general address, marked for Ethan's attention, and the subject line was, "Following up." It had been 4 months since the dinner where he'd told her they were done, and approximately 2 months since the wedding, which had not been publicized, but which existed, as events in a family with $4.2 billion in assets tend to, in the specific form of documentation that creates legal and financial reality. The email said she'd seen something in the professional network, a mention of his new title, and she'd reached out because she thought he should know she was genuinely happy for him, and she hoped there were no hard feelings, and she'd appreciated everything they'd had together. And she was doing well, and maybe if he was open to it, they could have coffee sometime as friends. He read the email twice. He understood what it was. She had heard, from somewhere in the professional network, or perhaps from someone who knew someone who'd attended, or perhaps from one of the 17 ways that these things move through the informal economy of people who track wealth, that he had married Alexandra Harrington. Not the employer, not the heiress he'd been sold to. As the woman who was now, in legal and documentary fact, his wife, and in whom, by virtue of marriage and the carefully negotiated marital property agreement that Ethan had reviewed and amended and finalized with the precision of someone who understood exactly what it contained, he had legitimate standing in the Harrington estate structure. The standing she had hoped, when she arranged the procurement contract, that she might eventually acquire through him. Proximity she had been purchasing with the $500,000 arrangement, whether she'd admitted that to herself or not. He sat with the email for a moment. He forwarded it to Alexandra with a single line. "For your awareness." Alexandra's reply came 3 minutes later. Noted. He went back to the Philadelphia acquisition memo. And the ground lease situation had fully resolved in the estate's favor. The forensic work had confirmed a qualifying use gap of 14 months in the relevant period. The reversionary clause had operated as drafted, and the property was now fully in the Harrington portfolio without encumbrance. He was writing a summary memo for the estate records, a clean account of the legal strategy and the outcome. It's the kind of document that would sit in a file and be useful to whoever came after him in 20 years when the property's history needed to be understood. He wrote, carefully. He wrote the facts in their correct order, with the correct citations, in the precise and unadorned language of someone who had learned that the clearest writing is always the most durable. He did not editorialize. He did not perform. The bathroom light flickered twice. He did not reply to Vivian's email. As Alexandra appeared in the doorway of the conference room at 2 o'clock with 2 coffees, the way she did sometimes now, without comment, the gesture having long since crossed from professional courtesy into something that was simply the architecture of their days. She set one in front of him and looked at the memo he was drafting. "Philadelphia's done?" she said. "Yes." "Full resolution." "Full resolution." He looked up at her. "I'll have the summary memo filed by end of day." She looked at the memo, then at him, with the direct, assessing quality that was simply how she saw the world, accurate and without theater. She picked up her coffee and said, "I saw the forwarded email." "I know you did." A pause. "Is there anything you want to do about it?" He looked at her. He thought about the question and what it actually asked, not whether he would respond to Vivian, and not whether Vivian's return created any emotional complication, but whether there was any structural matter that required attention. She was asking, in the language they shared, whether the architecture was sound. "No," he said. She nodded once. She looked at the memo again, and the small adjustment moved through her expression. She said, "Good." She turned and walked back toward her office, carrying her coffee, and he watched her go, with the specific quality of attention that he had stopped trying to categorize, because it was simply what the world looked like to him now. The 41st floor with its fluorescent light, and its sagging ceiling tile, and its smell of old paper and machine oil, and Alexandra Harrington at the center of it, moving with the particular precision of someone who has always known which walls are load-bearing and has finally found someone else who does too. He turned back to the memo. He finished it by 4 o'clock. He filed it. He pulled the next matter from the queue, a foundation endowment reallocation that had been waiting for 3 weeks, requiring a review of the foundation's investment policy statement and a legal analysis of the trustee's fiduciary obligations in reallocating between asset classes. He opened the foundation documents. He started reading from the beginning, left to right, front to back. Nothing skipped, nothing assumed. But the bathroom light flickered twice. He kept reading.